Hello and welcome back to State and Local Government and Politics. In Part 7 of Module 8 on the courts, we'll discuss problem-solving courts. Problem-solving courts, commonly referred to as specialized courts dispensing therapeutic justice, have emerged in most American states over the past decade. Problem-solving courts relieve overwhelmed legal systems dealing with persons and families whose actions stem from problems better dealt with by supervised treatment rather than incarceration or similar forms of punitive governmental sanctions. These courts represent an attempt to craft new, adaptive responses to chronic social, human, and legal problems that are resistant to conventional solutions associated with the adversarial process. Though lacking a precise definition or legal philosophy, problem-solving courts share a basic theme, a desire to improve the results that courts achieve for victims, litigants, defendants, and communities through a collaborative process rather than the conventional adversarial process. There are several factors that have led to the rise of special courts, including prison, state facilities, and jail, county and city facilities overcrowding, highly stressed social and community institutions, and increased awareness of social issues such as domestic violence. While increased social awareness has indeed played some role in the development of these specialized courts, the lack of resources available to state and local court systems has been the major driver behind the broadening use of such courts. The caseloads of the courts have increased substantially in recent decades, while the resources available to the courts have not increased proportionately. For example, from 1984 to 1997, the number of domestic violence cases in state courts increased by 77%. Problem-solving courts got their start in 1989 when Dade County, Florida experimented with a drug court. As of April 2007, the U.S. Department of Justice reported that there were 1,699 fully operational drug courts in the United States and another 62 tribal drug courts. Since this development in 1989, a variety of specialized courts have emerged, primarily designed to tackle difficult social issues. For example, New York City opened its Midtown Community Court in 1993 to target misdemeanor quality of life crimes such as prostitution and shoplifting. Instead of relying upon traditional sentencing involving incarceration, offenders were required to pay back the community for the harm they caused by community service work such as cleaning local parks, sweeping streets, and painting over graffiti. In addition, to address the underlying cause of the problem behavior, the offenders were mandated to receive therapeutic social services such as counseling, anger management instruction, substance abuse treatment, and job training. Typically, elements of the local community are also engaged in the work of problem-solving courts by participating on advisory panels, providing volunteer services, and taking part in town hall meetings. Evidence collected in evaluation studies conducted on many drug courts indicate that these problem-solving courts tend to achieve favorable results with regard to keeping offenders in treatment, reducing their drug use, reducing recidivism, and economizing on jail and prison costs. The rate of retention in drug abuse treatment ordered by drug courts is typically 60%, as compared to only 10 to 30% for voluntary programs. Moreover, drug court participants have far lower rearrest rates than do persons taken into the traditional court process. The types of problem-solving courts are many, but most of them fall into the categories of limited or general jurisdiction trial courts, courts of original jurisdiction. The most common specialized courts are those that work on social issues, primarily substance abuse, and family courts. Some examples of specialized courts include gun courts, gambling courts, homeless indigent courts, mental health courts, teen courts, domestic violence courts, elder courts, and community courts involving lay citizens in the process of arranging for property crime offenders to engage in compensatory justice with respect to those whom they victimized. Some states have taken it upon themselves to permit the establishment of specialized courts for the protection of the environment and for addressing the economic costs and benefits of pursuing sustainability. Such specialized courts have been created to deal with highly complex issues which require extraordinary scientific and technical knowledge on the part of the court. States are also developing specialized courts to manage economic disputes that arise in the course of commercial activities such as business formation, business transactions, and the sale or purchase of business assets. In many states which do not have such specialized courts, there has been a steady trend in the growth of the number and range of activities of administrative law judges. These hearing officers work within administrative agencies which engage in regulatory actions that give rise to many disputes: environmental regulations, labor management actions under collective bargaining agreements, compensation for damages incurred from state government's action on one's property, and so forth. These administrative law judges, or ALJs, hold quasi-judicial hearings, carefully weigh the arguments of the agency and aggrieved citizens, and have the authority to mediate, arbitrate, and ultimately decide upon an outcome to a case which is binding on all parties. While such decisions made by ALJs can be appealed to the courts, state court judges seldom overturn their rulings. In Part 8 of Module 8 on the courts, we'll discuss judicial selection.